Yeah, good afternoon, everyone. First, I would like to thank the organizing committee for giving us an opportunity to attend an online. I would definitely prefer to be there, but it is the beginning time of the universities in Turkey, so we are quite busy nowadays. While I am choosing a topic for this conference, I try to find a topic it's quite popular, and this brings me the point that the sanctions, because due to the recent war between the Russia and Ukraine, we have started the word sanctions from the media many times in the last couple of months. So of course that one of the area which the sanction regime are affecting is definitely the sea trade. Due to the time restriction I have today, it will not possible me to analyze every detail about every effect of the sanctions on sea trade. That's why I choose my topic just to focus on the charter parties. So what I will do today is this is the content page. I thought that it will be useful to give the main concept of time charter first, because I will look the effects of sanctions on time charters. And then I will go and give some details about the sanction regime. And the third part, I will look at the impact of the sanction regime on time charters. And this is actually the main part of my presentation. So let's start with the general overview on time charters. This part is necessary to understand how the sanction regime are affecting the time charters actually. The time charter is a contract for the use of the vessel and her crew within agreed trading limits as directed by the charterer in consideration for the payment of hire. So under this contract, we have the two parties, the ship owner and the charterer. So the ship owner is giving the usage right of his vessel to the charterer, and then charterer using his vessel and crew and paying them money in consideration of this usage. So here that the duration of the charter can change depending on the contract. It might be very short period of charter or it might be the very long one. Duration commences once the ship owner delivers the vessel to the charterer, and then at the end of the duration, the charterer is required to re-deliver the vessel to the ship owner. So here that what we especially know is that during this period, the ship is employed by the charterer, and then the charterer is required to pay charter hire. So when I use the term delivery and re-delivery, most of my students and also the people that are coming from the outside of this area think that, okay, this is like a lease contract. So it is like a going to somewhere and like a renting a flat and use that flat for a particular period of time, and at the end of the duration just giving the house to the owner again. So at the beginning, so this brings this question, is the chartering a vessel for a particular period of time is like a lease contract? The scenario actually seems a bit similar, but the answer to this question is no, because there's a very fundamental differences. And this is pointed out in the London Explorer case. And it's said in that case, under charter, there is no hiring in the true sense. The charter vessels remains in the possession of the owners, and the master and crew remain the owner's servants. So what the charter gets is a right to have the use of the vessel. So here, actually, what this quote is trying to say is that there is no transfer of the possession here. We are not transferring our vessel physically to someone else. So the physical control of the vessel is still in the ship owner. What the charter is doing is just to get the commercial control of the ship, so give some employment orders to ship owner. So you have the control of the vessel for a particular period of time, and you are doing this by giving an employment orders. So then what is an employment order? This is the questions that we need to ask, and how you will identify that the particular order is an employment order or not. So this is the Heel Harmony case. This is the point out. It says that employment embraces the economic aspect, the exploitation of the earning potential of the vessel. So within a time under the English law, through the cases, there are the couple of examples that I put here. For example, the selections of port of loading and discharge. So the charterer, let's say that I am a charterer, And I can say that my ship owner that I want you to go to this port and then load this cargo. So this is an employment order, because by way of giving such an order, I will try to get some earning. This is related to earning potential of the vessel. Similarly, instruction relating to loading, carriage, and delivery of the cargo, and the selection of the cargo that will be loaded on the board of the vessel. This is also an employment order. So once the charterer, if the charterer is giving an employment order to the ship owner, then the ship owner is just need to comply with that order, okay? So this is the main logic behind the time charter. Someone is getting the commercial control of the ship owner, and by way of giving an employment order, using that vessel for a particular period of time and paying a hire for that. So if the order is illegal, of course, at that point, the ship owner can say that, okay, just stop there. I cannot comply with your illegal order. He has such a right to do so, okay? So now let's move to, this is the time charter party. So I just try to give you the logic under this contract. And let's come to the analysis of sanction regime. What does that mean? So this is the definition which I get from the one book. It says that the coercive measure imposed by one country or coalition of countries against another country, its government or individual entities therein, to bring about a change in behavior or policies. And in another book, it says sanctions are penalties imposed by one country on another to stop it acting aggressively or breaking international law. So this is like the, when we think this in our daily life, let's say that you don't like one of your friends' behavior, and you are saying that until you change your behavior, I'm not speaking with you. It seems like that, but in an international level, the one country, if don't like another's actions, then they are starting to impose sanctions to each other. So, for example, due to the war between the Ukraine and Russia, UK has banned all the Russian vessels to enter into the UK ports. And then also again by UK in March, 7 Russian banks were removed from the SWIFT system. SWIFT is a system which the banks are using to connect with each other. And especially to make an international transfer, it is important that you are being, you are being a part of the SWIFT. So if the particular bank is removed from the SWIFT, then that means that this is a de-SWIFT action. And then that bank cannot connect with any other banks anymore. So they cannot send any money or receive any money from any other countries. So it's also very high level of sanctions. So these are the just examples that I want to show you. So what it is happening if we say that, for example, the UK banned all Russian vessels to enter into the UK ports. So what it is happening if the particular vessel come and enter into the UK, Russian vessel come and enter into the UK ports? This is, of course, the breach of sanction regimes, and the breaching party might have incurred significant fines and reputational damages. That's why it is important that no one shouldn't breach any sanction regime. So here I just want to mention very briefly the types of the sanction applied. This is changed depending on how you are wording your sanction regime. So, but in a general sense, there are the 3 types of sanction regime. These are restriction based on a place, restriction based on the banking sector and people, and then restriction based on the activity. So let's start with the based on the place. I want to mention those because I want to show you that how they are related with the sea trade. These are if there's a restriction based on the place, this is related to sanction imposed with regard to the geographical area. For example, the purchase, export, and transportation of prescribed commodities such as petroleum, petrochemicals, and natural gas from Russia. This is also one of the sanctions which the UK imposed against Russia. So here it doesn't restrict that import, export of these, or the purchase of these goods, or transportation of these goods from any other countries. But if they are coming from Russia, then they are restricting this. So that's why we are saying that this is a restriction based on the place. And the other group is restriction based on the banking sector and people. So you may say, okay, how the restriction imposed against the banking sector can affect the seat rate. It is not affecting directly, but it is affecting indirectly, but in a very significant way, because if there is a sanction imposed against a particular bank, it affects how they get to be paid and how they make a payment. So in terms of the banking sector, there are 3 types of restriction apply, and level of those are different. For the first one is asset freezing, the second group limited restriction, and the third one is a D-SWIFT. I have already explained what the D-SWIFT means. But asset freezing, for example, a ban on all transactions related to management of its reserves and assets. For example, again, the UK impose a sanction against all Russian banks about the asset freezing. So it means that if any payments come from one of the Russian banks, it is rejected by the UK banks. So this is a good example for an asset freezing. So the other group is restriction on people. This is the most popular one. So this can be against the natural person or legal person. So these people are known as a designated entry. So one country is saying that, okay, all these people are designated entity, and I don't want any of you, let's say from my country, to do any job with those things, those people. So, for example, the US, EU, and UK have together sanctioned over 1,000 Russian individual and business, so the companies, and there's a list they are created, those created by the UK, for example. There is 1,000 people in that list, and then the people are not, these are designated entities, so you shouldn't do any transaction, any work with those people. So this is the sanctions which they are imposing. And then the third group is restriction based on the activities. Here, regardless of the geography or people, here the activity itself is restricted. So shipping activities to Iran was prohibited by the US, for example, in the past, still continues in some extent. And US also is banning all Russian oil and gas imports, and then the UK will phase out the Russian oil imports by the end of the 2022. So here the activity is oil imports, oil and gas imports, and it is restricted. So this is the general, all the information that I give you now until this point is the general things about the sanction regime. Now I will try to bring the first part and second part together and show you how these sanction regimes are affecting the charter parties. So here the problems are arising in 2 stages. The first stage is the beginning stage, and then the problems arising at later stage. The first, we will look at the beginning stage. What is a beginning stage when I say the problems that might arise at the beginning stage related to sanction? So beginning stage is actually the time which the parties enter into a contract. So here the most problems are arising related to, related to restriction based on the people. So as I mentioned, the designated entity issue. During the sanction regimes, the charterer, let's say that you need a vessel and you want to charter a vessel from someone. So the charterer should be careful regarding who the owner of the ship and also the nationality of the ship. Similarly, the ship owner should also be careful who the charterer is, because if you are chartering a ship from the ship owner, who is the one in the designated, who is the one announced as a designated identities, then there will be a problem. Or if you are chartering your ship to someone who is announced as a designated entity, again, there will be a problem, because in that case, it means that you are breaching the sanction regime. So the charter should be diligent to ensure that they don't contravene any sanction regulation by chartering a ship from targets of such restriction. If the charterer charters a ship on whose nationality or ownership sanctions are imposed, they may be in breach of sanction regulation depending on the scope of the sanction regime. And the similar thing is also valid for the ship owner. The ship owner should be careful about chartering their ship to the target of such restriction. Again, they may be in breach of it's a breach of sanction regime. So following the breach, what it is happening, as I told you, if you are breaching a sanction regime, you will pay a fine and you may also be prohibited from the trade. So here, the important thing that we need to know, how does someone who wants to charter a ship will avoid from such a situation. So the best way is for the charter to check the special designated national list. So there's a list published by each country, and then in that list, the designated entities' names are written, real person, and also the companies and the business ships, all these things are written there. And if it's a real person, for example, date of birth, and then the mother and all the details about that person, or if that person has a particular ship, those ships' names are also written in that list. So there is a list about designated entities. So the first thing is, of course, to go and check the list and see whether your potential ship owner is in that list or your potential charter is in that list. And if it is not in that list, you may first feel yourself secure and enter into a charter, or you can say that, okay, he's not in the list, then I can feel free myself and enter into a contract. But this is not enough. It is not just enough to check the list to feel secure in some cases. Why? Because designated entities always try to find a way in order to keep themselves out of the list. So the list might not reflect the accurate situation. You might ask, okay, how is this can be possible? Because the governments are publishing those lists. This is happening in that way. Ship owner companies are changing the ship's flag, register name, and register ship owner. So although that in reality, the ship is still like controlled by someone who is in the CDN list, in the physically, it seems like that that ship is another person's ship. That's why that's why the checking the list is not just enough on its own. For example, Iranian companies at the beginning of the sanction imposed by the US against Iran, 123 ships of Iranian shipping lines were on the CDN list, but now a majority of them seem to be owned by the other companies, and Russia has started to do the same things. So what is happening as a consequence is all these tactics, of course, help the ship owner to escape from sanction regulation, but on the other hand, create a risk for the innocent charterer, because you are just checking the list and you say that, okay, the ship owner is not here, so I can enter into a contract. But once you enter into a contract, you are noticing that that ship is actually related to with someone in CDN list. So that's why if the charterer wants to feel themselves insecure, and similarly, if the ship owner wants to feel themselves secure, the best way will be the BIMCO sanction clause for time charter parties 2020. This clause is not in the standard charter form, therefore the parties should put this term on their own. This is dealing with the situation that the problems that might arise at the beginning stage. It says that in the B and C, or in the B, owner's warrant at the date of this charter party and throughout its duration, the register owners, bareboat charters, intermediate disponent owners, managers, the vessel, and any substitute are not a sanction party. And under the C, the charters warrant that at the date of this charter party and throughout its duration, they and any sub-charters, shippers, receiver, and cargo interests are not a sanction party. So here, if you put such a clause in your contract, then this means that you are in safe position because you got a warranty from the owners, and you also got a warranty from the charterers that they are not a designated entity, and if there is a breach about that, then the party may terminate the contract and also claim the damages resulting from that breach. So these are the problem that is arising at the beginning stage, and I will now move the other group analysis, the problem that might arise at later stage. Let's say that you enter into a contract. You like your ship owner likes you, everything is going well. but suddenly that sanction regime has started to be imposed, and your ship owner has started to be one of the designated entity. Now she's a restricted person, in other saying. Or maybe you are doing a particular activity, and then but that started to be not allowed anymore. Let's say you are doing an oil imports from the Russia to the UK, and you charter that vessel for this purpose. It's for 1 year period, but 6 months passed, and then the activity is restricted. Oil import from Russia is not allowed anymore. So that means that you will not be allowed to do such a things. And the third one is type of the cargo on the board of is not allowed anymore. Or lastly, entering into a port which the ship is proceeding to. So let's say that you have time charter and you are using to carry something but your ship is a Russian ship, and you are using that ship to carry the cargo from, let's say, Turkey to the UK. But since this is a Russian vessel, the UK is not accepting that ship anymore into his ports. So this might also be the case, and actually this caused a lot of problem in the last couple of months. And so in that situation, the first things that comes to people's mind and everybody's mind, so the operation that was originally legal has started to be illegal under a relevant law without the fault of either party. So there's no fault of the party, but something happened, and now that action or that act is started to be an illegal. So what will happen in such a case? Will it be accepted that both parties will in breach of sanction regime and required to pay fines? So here that we should check the wording of the contract, of course. Maybe the first major clause will help. But the more safer option will be the sanction clause, of course. I will comment later. But now I just want to focus on what will happen if your contract is silent and is not saying anything about this. Common law principles might get enforced here. The first thing, the doctrine of frustration. We know that under the English law, although that there's a doctrine of frustration, British people are not so willing to operate this doctrine because they assume that the contract should stay alive as much as possible. We should keep it over everything. So it is quite difficult to operate this doctrine, but if you convince the court, why not? So let's come to detail. What is the doctrine of frustration? Frustration occurs whenever the law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. So it was not this that I promised to do. So by relying on that, you might say that you might claim to frustrate the contract. So you can go and say, look, I agree to do something legal. Let's assume that you are carrying oil imports from the Russia to the UK. So you are going, as you want to use your vessel, and then you are using for a particular period of time, and then the sanction has started to be imposed, but you are not allowed to do such a things anymore. So in that case, you can say that, look, at the time the contract we made, this was something that is not problematic. But now, due to the sanction imposed, it has started to be illegal. So this is not something we agreed to do. So let's bring to the contract and relying on the doctrine of frustration. So this might work. And if it works, then the contract will be terminated automatically. And also the parties will release from their future duties and obligations under the contract. And also any rights arising before the frustration remain binding and enforceable. And lastly, any collateral contracts such as bill of lading will also be frustrated in such circumstances. So you can say, okay, what if there's a cargo on the board of the ship, and then let's say that ship is coming from the Russia to the UK. This is a Russian vessel, and then UK said, okay, I am not allowing the Russian vessels to enter into my port. So here, that relying on the doctrine of frustration, if the contract comes to end, what will happen the cargo on the board of the ship? Here, that even if the contract is frustrated, if there's a collateral concept such as the bill of lading, of course that as a carrier, we know that he's also the bailee of the goods. Then he will be, he's required to, under the common law, he's required to carry the cargo in a safe way and also discharge the cargo in a safe place. And during those periods, the charterer will pay the money to the ship owner for the time that is necessary for that, okay? And so what if the particular charter operation is unenforceable, but both parties have agreed to do it with knowledge of the illegality or potential illegality? So in such circumstances, they will not be able to use the court or arbitration system to enable them to recover any losses or damages, because this is the result of the public policy consideration. Judicial systems are not intended to assist the parties to break or evade legal responsibilities. So now I show you how the doctrine of frustration works here for the problems that might arise at later stage. And also dangerous goods might be helpful, relying on the dangerous goods ground. So under the common law, a charter has a duty to ensure that the ship does not contain dangerous goods without giving notice to the carrier of the dangerous nature of the goods. Why we have such a rule? Why we have this rule? Because if someone will carry a dangerous good, he should be aware of that, and then he should decide to get such a risk. Like imagine that someone wants to carry an explosive and he's not telling to the carrier, and then he's suddenly finding himself in a position to carry an explosive. So if he knows that, if he had known that, maybe he would have refused to do such a things. It is important that the carrier is informed in terms of such a thing. And when I say the dangerous good, the first things that comes to every person's mind is probably physically dangerous situation, but particular goods can also be dangerous in a political sense, and this is especially in a case during the sanction regimes. So if the import or export or the carrying the particular cargo, let's say it's the oil and the chemicals or any other type of cargo is restricted under the sanction regime, then we can say that that cargo is also dangerous, but this time dangerous in a political sense. And in that case, that once the goods becomes the dangerous in a political sense, the ship owner has the right to terminate the contract and claim the damages for any losses that he may have incurred as a result of such shipment. And lastly, the unsafe ports. So at the beginning, while I am mentioning about the time charter, I told you that the charter is entitled to give a right to orders to the ship owner, and these orders can be related to ports. So I can say that I want you to go to the ports in Split, or I want you to go to the port in Istanbul, and the ship owner is required to comply with this order, but on the condition that that port needs to be safe. So the safety can be defined. A port will not be safe unless in the relevant time the particular ship can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. So, for example, if you are saying to your ship owner, please go to the port, but there's an attack in the port, or there's a war is happening in the port, then that port is not as safe anymore, and then the ship owner can say, no, I'm not going there because the port is not safe. So here the port can be dangerous in a legal or political sense too. So if let's remember the UK example, they banned all the Russian vessels to enter into UK ports. So for example, if you are ordering your ship owner to go to the UK ports while the ship is a Russian flagship, then the ship owner can say, look, this is a dangerous port in a political sense. So in that case, the ship owner has a right to terminate the contract when he discovered that the port is dangerous in a political sense, and again claim damages for any losses that he may have incurred as a result of such a shipment. So these three was the basis for the common, can be operated relying on the common law rules. But again, the safe option will be, of course, to have an express clause in that regarding this situation. And the BIMCO sanction clause for tank charge parties 2020 is actually works related to problems that will arise at later stage too. It says expressly saying that the charterers shall not give any orders for the employment of the vessel, which involves a sanction party or sanction activity. So if you are giving an order which include a sanction party or sanction activity, then relying on that clause, ship owner will be able to say that, okay, I'm not complying with this because this is an order you cannot give. And also under the F clause, F part, it says if the vessel is already performing an employment which involves a sanction party or is in a sanction activity, let's say that you are oil import from the Russia, and then you are in the middle of the sea, and then the sanction has started to be imposed. So this falls within this clause. It says that in that case, the owner shall have the right to refuse to proceed with the employment. So he can say, okay, look, the sanction has started to be imposed and I'm just stopping here and I am waiting for alternative voyage orders. And they will give the charterer 48 hours for this. And during the 48 hours, if the alternative voyage order is still not coming, then the ship owner can terminate the contract. So this is the...
I'm sorry to interrupt you, but another... Okay.
So this is the... No, I don't have any other slide. This was just the explanation that I have already made. So thank you for listening.